Good afternoon, everyone. Professor Faisal, Mr. Dhar, Mr. Mandal, Mr. Shah, and all members of the Fox and Mandal family and students from various colleges who have joined us on this Saturday afternoon, leaving aside all their interesting activities or afternoon naps. We are gathered here today for a very unique moment because the oldest lawyer amongst us and the youngest one has not been taught these new criminal codes which have come into effect earlier this month. And therefore, it has given us this back to college moment where we have textbooks in hand and a professor in front to take us through the new changes in the law. We hope to make this session engaging and interesting for everyone. And before we begin, just a few safety instructions. We have two exits, one in the front and one at the back. In case of emergency, you are requested to evacuate through the stairs. And I request everyone to keep aside their cell phones, preferably on silent modes. And I hope to see everyone enjoy this session. We will have a session from 3:15 to 4 o'clock, after which we will have a break for 10 minutes for refreshments, followed by the second part of the session. And last 15 minutes from 4:45 to 5 p.m. will be reserved for question and answers. So I request the audience to pay attention and also note down all of their doubts for the Q&A session at the end. I now request Mr. Saurav Bhagat, partner, to kindly welcome our guest speaker for today, Mr. Faisal Fasi, Assistant Professor of Law from NUJS, and say a few words for him.
Mohima, good afternoon, everybody. Distinguished guests, Mr. Ashok Dhar, Senior Partner, Fox and Mandal, Mr. Devanjan Mandal, Managing Partner, Fox and Mandal, Mr. Faisal Faiz, Assistant Professor, NUJS, Mr. Dilip Shah, Professor, Bhavanipur Education Society College, Arindam, and my friends, colleagues, juniors, students, and all interns. So it gives me immense pleasure to welcome all of you to this 2 days workshop. Today is the first day of the workshop where it will be conducted by Assistant Professor Faisal Faiz. So the workshop is basically on the new criminal codes, which has come into force on 1st July 2024. We all know that criminal laws, basically major laws, are where IPC, evidence, and the Criminal Procedure Code, which has been in force almost more than 150 years. Now this law will be replacing the earlier laws. The names and the procedure, we need time to get used to it. The Bharatiya Nyaya Sanhita will be replacing the Indian Penal Code. Bharatiya Nagarik Suraksha Sanhita will be replacing the Criminal Procedure Code, and the Bharatiya Saksha Abhidhan will be replacing the earlier Evidence Act. So already we have various litigations, judgments which are been passed with regard to the implementation and application of these laws through this in the proceeding which are pending. So without going into the details, which will be, I think, dealt with by him, I will just give a brief introduction of him. He teaches at the NUJS. He is also a director of Central for Studies and Research and Consumer Laws. After completing his LLB, he practiced for around a year and has been teaching and researching full-time since 2010. He is qualified for the National Eligibility Test conducted by UGC. UGC has also awarded him a Junior Research Fellowship. He has received Gopal Subramaniam Scholarship awarded by NUJS for his outstanding performance in the Master of Law. He generally teaches criminal law, consumer law, and forensic science in NUJS. Besides that, he also imparts training to various professionals on different aspects of law. His trainees include member of the bar, member of the bench, police officers, members of consumer commissions, registrars, corporate professionals, and paralegal volunteers. He has also published in various reputed journals on several themes, including application of cognitive psychology in criminal law, anti-conversion law, relevance of expert opinion in sexual offenses, matrimonial offenses, data protection, and Islamic banking. He has also presented several papers in international and national conference, and he has delivered various talks. Before he starts his workshop, may I request Mr. Dilip Shah to present a memento to him.
Hello. Well, on behalf of the college, I think we are very happy to have you. I have met Mr. Faisal, I don't remember, many, many years ago, and I always wanted him to be a part of the college, but somehow I lost his card, which I found today. So Faisal is here, we welcome you, and we welcome Fox and Mandal. And students here, I think it's one such effort which Fox and Mandal has taken, which we would like to welcome wholeheartedly. We would like to have this kind of an interaction. We are also having this kind of an interaction with Ad Club upstairs in the Jubilee Hall, where the chairman of BBDO is present. So the whole idea is that the students must see people who practice law or practice whichever sphere in which they want to excel, and they should also have experts sharing their inputs in it, and it should all be on contemporary matters. And that's exactly what this entire effort is. It's not just today's discussion. As I have been teaching law myself, I believe that today we should be dealing with the substantive part of the law, and I think the next day on 27th we should maybe get into the procedural part. Substantive is always a little more engrossing. Procedural is a little more detailed, but I think that both of them together will supplement and complement, and that's how we'll get a better understanding of law as a sphere and the changes that are happening. So once again, we welcome Fox and Mandal and the faculty. Bhawanipur is more than happy to have this kind of a session, and we like to have it more often. Thank you so much for hearing me.
You need this much light? Yeah. So ask them whether it's visible from the end, from that side. Can we start? Yeah. All right. Very good afternoon to everyone out here. See, straight away coming to the question, the first generic question is about that what is the nature of the change which has happened, because a lot of talk has been going on, as somebody rightly pointed out, 150 years old law, and completely whether we have a complete new set of law, I just like some cosmetic change or modification has been done. So if you go with number wise, there are a lot of changes. This number, it's around, for BNS, that is Bharatiya Nyaya Sanhita, it's around 170 provision they have changed, but those changes include changes of comma, a word, and even about, what should I say, it's about clarifying one or two words here and there. But when it comes to substantive change, so it's not more than 5 to 7%. So just keeping it very general, it's around 90% thing we have retained exactly what was there. So this notion of giving that we are done away with colonial era, that is something which we have to ponder over when we'll go through the provision. So the purpose of today's presentation is mainly to highlight all the changes which have taken place, what is the impact of the changes, and for that there are, the first question for me is that whether all these changes are from, like suddenly it is, there's some background there. So what I have found that there are 3-4 main sources of all these changes. The first source is the thing which was local law in a technical sense. That means having a regional application. For example, you are aware of that in Maharashtra since 1999 there was MACOCA, Maharashtra Organized Crime Control Act. So it was applied to Maharashtra, which was taken up by other states. So right now the application of organized crime control was confined to 7 states. That has become the national law. So suddenly you realize the thing which was not crime in Bengal, it has become crime from 1st July. So the first source is the thing which was having a regional application that has become the national law. One. Second source was the law which was special law. A special law means the one which is confined to one particular subject. Some of the provision of the special laws has been made into the national law, that is BNS. For example, the best example is UAPA. So you are aware of now terrorism is a part of the general law. So this is the second source. The third source is mainly taken from the guidelines given by the Supreme Court from time to time. So something like say mob lynching has been taken up from the case, for example, Tahsin Poonawalla case. And of course the community standard has been incorporated here. So looking at all these changes, it is not like suddenly something has crop up from somewhere. So either it has been borrowed from the thing which was already in existence as a form of the special legislation, or it was having a regional application. So when we look at changes, so the 70 provision they have changed, you will find around 100 is just about increasing the fine, amount of fine, or the years of imprisonment and all that. The major change in punishment is the introduction of community service, which was not part of the Indian jurisprudence. For the past 1 week, now we have a new kind of punishment, that is community service, which is applicable in 6 provision. So I'll start with the community service. Yeah. Oh, what? Oh. All right. So here you can see the term community service has not been defined in BNS. There's one reference given in the procedural law, that is BNSS, Bharatiya Nyaya Suraksha Sanhita, where they have said that it's a form of punishment which benefits the community and there should not be any kind of remuneration. But we don't know that what exactly is this form of punishment, what will benefit the community, that they have not explained. All they have mentioned is in this 6 categories of offense. For example, defamation, that is something noteworthy. Theft of less than 5,000 rupees if the money is recovered. And then, a small offense, somebody trying to commit suicide to compel public servants. Only in this 6 category of cases, a court can award community service, but the complete discretion is given to the court, that the court has to pick, the judge has to pick that whether a particular thing qualifies for community service or not. So there's a big gap over here, and this is something, if we have to make the analysis of the law, this is the first pointer. One of the major limitations of all the 3 changes they have done is about the clarity is not there in the law in terms of explanation of the term. For example, community service, they have mentioned the provision, but they have not bothered to define what exactly is community service, whether it is confined to just planting of trees, or like we don't know what exactly is going to happen. So this is one typical thing which you'll find for all the 3 laws, that they have incorporated certain things without explaining, without giving any guideline that how it is going to be get implemented. So coming back to the first slides. Yeah. So from the punishment side, as I said, the only addition in the form of punishment is community service. The quantum has been enhanced, and there's one more change from the punishment. They have also clarified about life. So there's a general notion that life means 14 years, 20 years. They are done away with that. They have clarified that wherever life is mentioned, they have mentioned natural life of the person. So what essentially they have done, they have curtailed the power of the executive in certain cases. So wherever, say, especially in offenses against women and children, say in rape cases, now life means natural life of that particular particular person. And this is a very important move because we are aware of cases like, say, Bilkis Bano case, where 11 people, the executive applied the power to remit the sentence. So that power has been curtailed through the legislation. So that is one important change regarding quantum of punishment. Now coming to the offense, which is the part of major discussion today. So offense can be classified into 3 categories. The addition they have made, so that I have listed. These are the 9 major addition. Then modification, they have made modification, gender neutrality, inclusivity is there. And of course, they have deleted some of the other offenses, which we'll take at the end. So what I have done, I have made it theme-wise. So we'll start with offense against human body, then we'll move to property, and if we get time toward the end, we'll come to smaller offense. So the first major introduction is about the offense of mob lynching. Again, there's the same problem. They have not defined what is mob lynching. So this is, if we get hang of this particular offense, we'll understand that what is the nature of the change they have done over here. So you can see over here, this is the punishment of murder. Second clause, 103 part 2, that is about punishment for mob lynching. The punishment is exactly same. Punished with death, which is rarest of the rare category, or life, and shall also be liable for fine. So automatically the first question comes, there are 2 questions which comes over here, that what exactly is mob lynching? It is not defined anywhere, and why at all a person should file a case of mob lynching when the punishment of murder and mob lynching is exactly same. So when we break this section, so this is what we are getting. It's a case of murder, so prima facie it appears that it's an aggravated form of murder committed by 5 people. But we are aware of the law. Earlier also, we had an idea of common intention, which is still there. So it's just like 5 people committing murder, so we could apply section 34 of IPC. It seems it is exactly same, right? But there are 2 ways of looking at this. One is there's an additional requirement for the prosecution to prove a ground, one of these 6-7 grounds. Again, it's an inclusive provision. Okay, this is another hallmark of the law. Most of the changes they have done, it's inclusive in nature. They have not created exhaustive provision. So the problem with inclusive provision is one side is more and more thing can be added, but this will be a breeding ground for controversy. Because a person will argue that a particular factor X will fit into mob lynching, the other will argue that it will not fit into mob lynching. So this is not only confined to this particular provision. If you look at other changes, this inclusive nature of the law will be going to create controversy. So over here, when we look from the literal sense, then murder plus additionally, we have to prove the ground. Acting in concert is a simple meaning of common intention. So it seems that prosecution will not go for mob lynching because it will be difficult to prove. But the other way of looking is proving mob lynching will be easier for the prosecution rather than going for murder committed by 5 people and applying common intention, because the moment this ground is proved, that can become one of the important piece of evidences for proving that they were acting in concert. Now, the best way to understand all these changes when we connect the changes with the contemporary development which is happening. So this particular provision, you'll find if we track the development of a state like Uttar Pradesh, why people are getting lynched, or even in Kolkata for the past few days, it is coming in newspaper that people are getting lynched because somebody has committed theft of mobile phone and all. So that will give an idea that what is the purpose behind this particular thing. So the first we'll look over here that what are the grounds of mob lynching. So see, 6 grounds are there: race, caste, sex, place of birth, language, and personal belief, and any other ground. Now, for the student of law like us, this becomes very, very crucial. We know that there's a principle of aegis dum generis, that similar kind of thing can be included if it matches with any one of these 6 grounds. Now, what is the common part and the interesting part of this particular ground is all the ground has been taken from the Constitution. So if we apply, say, Article 15, if we apply Article 29, so this ground you will find. So basically, what is the message given over here? The social message is that someone who is having some kind of ascribed identities, that should not be a basis of discriminating a person to the extent of causing death. So if we apply Constitution over here, we should be the best guiding force for interpretation of, obviously, for the new law. So something like Article 19 and 21 can fit over here, and one can easily argue that cases of, say, for example, honor killing committed by 5 people can be considered the case of mob lynching. Now, since we don't have a clear statute on honor killing, so something like honor killing can fit over here if committed by 5 people. Similarly, the cases of mob lynching, the one which is happening in, say, Uttar Pradesh, that somebody involved in some kind of profession, Say, we know that if a person is consuming something, say a person is consuming non-veg or involved in profession like this, so those people are getting lynched. So over here, something like profession we can fit. So this is the advantage of the new law in one way of saying that that's an inclusive law, more and more thing can be added. But as is pointed out earlier, that the thing which will fit in other ground from my perspective, that may not fit from your perspective. So it is going to create controversy that what exactly is the meaning of the offense in the first place, or forget about proving of it. So summing up this, as I said, that there are two extremes. One extreme is the layman's understanding that it's difficult to prove mob lynching because there's an additional requirement. But when you look from the technical point of view, so proving of this ground, that will help the prosecution in proving that people were acting in concert. And why I'm making this particular argument? I'm making this particular argument because there are dedicated group involved where they are, it's a target killing, like targeted killing of people. So especially, again, picking up a case of Uttar Pradesh, you will find that set of people involved where their job is to, not to follow the due process of law. And if somebody is involved even in illegal act, let's lynch that particular person. So it's a message given to those kind of people. So it will help the prosecution that, see, there's a dedicated, targeted set of people. They are involved in this kind of act. So it becomes easier to prove that they were acting in concert. So the idea why I'm highlighting this is not to just impress upon the meaning of mob lynching. It's mainly about understanding the approach of the new law. So this is not the only provision. Since I don't have time to go through all the provision, you will realize there's something very, very common that they are talking about inclusive provision. So the guiding light obviously should be Constitution, should be the first force, that if something can be figured out from Constitution, that will fit in this inclusive provision. So this is about the first offense. This is not an offense, but this kind of provision you will not find anywhere. Forget about India. I'm not aware of like anywhere in the world you'll find this kind of provision. What this provision is about, that if a person has committed a wrong, whether it is a case of negligence, deliberate killing, and if that person doesn't inform the authority, then the punishment will be double. So the normal case is, in case of rash driving, which is subject to, the matter will come in the court, whether it was the fault of driver, pedestrian, whatever. The moment this thing happens, if the driver fails to inform the authority, then there'll be double punishment. So double punishment means 5 years become 10 years. Now, what is the rationale of this? The rationale is given in this particular case, Dil Bahadur case. So this is basically from the research of medical science, which is called, golden hour rule. The first hour of accident where most of human life can be saved. So just to ensure that the authorities are aware of that somebody has met with an accident so that human life can be saved, they have come up with this particular provision. This is the only provision among all the three laws which has not been taken into effect. That means this is not implemented. So maybe in future the government will announce this particular law. But the unique thing is there is nowhere you'll find this kind of law where the person has not informed the authority and there'll be double punishment. So there's nothing much in this. Let's start with some serious offense. So the first one is obviously organized crime. So organized crime, what they have done, simply they have, another interesting part of the law, they have borrowed ideas. They have borrowed ideas not in terms of principle, they have borrowed verbatim, like word by word. So this is one, again, classic section where they have simply borrowed word by word from Maharashtra Organized Crime Control Act. Now, why it is important to know, because if we have to look for interpretation, then the cases which are decided at the state level, say the local condition of Maharashtra, chances are tomorrow if the matter happens in Kolkata, same interpretation will apply for Kolkata when the organized crime event happened. So if we break this, so there are 4 aspects of organized crime. The first is about the nature of the wrong, the execution, means and purpose. So these are the 4 categories I have divided into this particular offense. So the first is that what exactly is the nature of this organized crime? The answer is that it should be continuous unlawful activity. They have given example. Again, you follow the word including. So just like mob lynching and other provision, as I said, that mostly the provision are inclusive in nature. So in something as serious as organized crime, where death sentence can be a valid punishment, again, it's the inclusive provision where they have mentioned kidnapping, robbery, extortion. So this is just a random pick. Without any having a proper rationale for why they have kept kidnapping, but they have not kept, say, abduction over here. So the first is it should be a continuing unlawful activity. The meaning of unlawful activity, they have explained that. Thankfully, this is the only provision where they have given some clarification, because it was already there in a state level law. So if a group of people, that means 2 or more people involved in a crime, and if they were charged sheeted twice in the last 10 years, so they will be considered that they were acting and they were involved in continuing unlawful activity. So the requirement is from 1st July, say a person commits a crime, which should be a normal crime, say before 1st July. But now what will happen is, if 2 charge sheet submitted, the magistrate has taken cognizance, that may become an organized crime. The moment it becomes organized crime, then you have a completely different set of laws, a different set of punishments. So this is something which is a message against given to the habitual offender, that someone who, so it basically about the present law is fearful of numbers. So when we apply scholars like Glanville Williams, so they always say that, see, law is fearful of number, because if a person intends to commit a wrong alone, so execution is very tough. But if there are a group of people involved, then execution becomes easier. So the law is also strict when it comes to habitual offender. So over here, what they have mentioned, that if 2 charge sheet was submitted against a group of people, so the third time when they come, that will be a case of organized crime. So the first requirement is it should be continuing unlawful activity. Second is, again, this is a very interesting point. Generally what happens in case of group liability, that any member of the syndicate, any member of the group commits the crime, there is a vicarious liability of all. That is a common sense. They can act jointly, they can act singly, that is settled. But over here there's something interesting. Say there are 5 people, they're acting in concert, there's a gang. They don't have to commit crime. They hire the 6th person who is no way connected with the group, having no knowledge of that there's so many people involved in the group. If that person commits crime, because hired by the group, that is also organized crime. So the situation is, say there's a group of people, a gang, that are involved in committing crime for the past, say, 20 years, 30 years. Now, I'm not aware of this. One member of the gang hired me to commit a crime. Now, I have committed some crime, random theft, cyber crime. So the law will, against me, the law will have committed organized crime. That means it is no more confined to vicarious liability. Up to vicarious liability is covered by the law. But this is for the first time, you'll find that the person who is not a part of the syndicate or group, still he will be charged for, the group liability. Then means is not very important, because in every crime there will be unlawful means. The last is very important, that what is the purpose of this particular crime? And this is important for the one who is dealing in economic offense. So those lawyers who are dealing in economic offense, organized crime is going to become a major thing which is going to be added in the charge sheet. So over here you see direct or indirect material benefit, including financial benefit. So something which was a matter of civil law, something which was a matter of a contract, or maybe a simple case of cheating, breach of trust, there is a possibility that that thing will be converted into organized crime if it is the third time that person is involved in that. So how we separate something which is the case of normal crime with organized crime, apart from the 2 charge sheet, is the requirement material benefit. Now imagine there are 5 people, say we are a gang of people, somebody apprehends me, I inform my gang that, see, somebody has apprehended me, so we have to take revenge from that person. Now 5 of us, we go and we actually kill that person. This is not organized crime, because over here the purpose is not material gain. The moment it becomes material gain, it becomes organized crime. So those who are dealing in economic offenses, again I'm repeating, this is going to be a major section from the future. The moment the person has committed crime, or there is a 2 charge sheet has already been submitted. 2 charge sheet, that means conviction is not required. That means the 2 cases are pending, the third case will be organized crime. And the punishment is more than others. Okay, the another thing about organized crime, and this is also a new addition. So if you are thinking of draconian aspect of the law, so this is the first provision which talks about the draconian nature of the law. It's not about getting away from the colonial legacy. In fact, it is like colonial legacy plus kind of. What we know about the present IPC, preparation is not a crime, except in 2 situations rather. If it is against the state, waging war against the state, and second is dacoity. That's it. Preparation is never a crime. Now we have a clear case of organized crime where mere preparation is a crime. So what happens from here, what is preparation or not is a question of fact. There are guidelines given, so I'll not go into that. So the question of fact, why I'm saying is because again, it's a perspective. From one perspective, a particular thing is preparation. From other perspective, that may be attempt, that may be not even preparation. Now take a very simple example. Say for example, I'm involved in some petty offenses, maybe some kind of cybercrime here and there, and I have also kept illegal gun. Now if the gun is recovered, that's a clear case under the Arms Act for possession of illegal gun. That much it makes sense. But what will happen now? If there are two charge sheets against me or anyone connected with me as a member of syndicate or gang, they will say that I was preparing for organized crime. So it becomes, it's not a good law in the sense the clarity is not there. Maybe deliberately it is done because this thing is in practice, already in practice in 8 states. It started from Maharashtra because of the local condition of Maharashtra, but now it becomes a law for the entire country. So something where mere preparation is a crime, that should be taken very, very seriously because a lot of power is given to the state, where state can interpret a particular act as preparation rather than just, something which a person involved in some kind of illegal activity, as I said about example of gun. So this is one thing which is very serious for me. Okay, among all the provision, this particular thing is the most interesting and most off the mark. When you read this particular provision, you will not even find the smell of human body here. This is offense against human body. Now, I don't think anybody in the world will find anything related to human body here. Petty organized crime, it's a serious human body offense. Now, either it is a bad piece of amendment, whatever, but at least I am not aware of, I don't find even a smell of human body here. That what is about human body? So you can see gang involved, theft, snatching, cheating, selling of ticket, betting, gambling. So all related to property, money, gun. Again. But for some reason have kept this under human body. So that is the limitation. That it's not have been in property. But what is the relevance of this particular provision? The relevance of this particular provision, unlike organized crime, it's not connected provision. These are completely independent of one another. So the scheme we had, PC, that the base form of the offense, aggravated form, they have not heard. So the first impression is that there is some connection between petty organized crime and organized crime, which is absolutely wrong, because these two are not connected at all. Now, what they have mentioned over here, just being a member of group or gang, again, they have not defined what is group and gang. So going with a normal interpretation, when two persons involved in any particular act, that may qualify for group, that it is done by a group, right? So then they are saying theft, snatching, all this. So the question is that whether every theft, snatching, or whatever is committed by two people will become organized crime or other petty organized crime, that is the question which we have to figure it out. It seems yes. That means suddenly the punishment, which is 3 years punishment, will become up to 7 years. So, and another thing to note over here, there's a minimum sentence they have mentioned. So apart from this provision, there are a lot of provisions where they have mentioned minimum sentence. Over here, minimum sentence in 1 year. So the implication is if you pick up the offense of theft, today the valid punishment of theft minimum is mere imposition of fine is valid. And the maximum it can go to 3 years. But over here, the minimum is 1 year, and it can go to 7 years. So that means it's a kind of touch and go situation where 2 or more people are involved, that whether it is a normal case of theft or whether it becomes a petty organized crime. Now, what is good part about this, this is a very contemporary provision. When we look at the explanation, especially the interesting one for me is strict theft. This is not a part of Indian jurisprudence. This has been borrowed from a foreign jurisdiction because in UK and other places they use this term trick theft. Trick theft is about covering all the contemporary cases, especially where youngsters are involved. For example, the cases of cybercrime, like OTP case and all. So the meaning of trick theft they have not defined, but I have read in other jurisdictions that the way they interpret any kind of manipulation, any kind of fraud, cheating, committed for the purpose of wrongful gain. That means any kind of undue advantage taken by the person for the purpose of committing theft, that becomes strict theft. So this is an aggravated form of theft in foreign jurisdiction. So over here, what they have done, the idea maybe behind that was that, all these people who are involved in manipulation of OTP and all these things should come as a petty organized crime, because generally group of people are involved in that. So this is something where, for me, as I said, this is off the mark. But again, the common pattern you can see here, any other similar act. So they have mentioned 6th ground, any other similar act. Now the question is, what are this similar act? If we connect theft, snatching, cheating and all this, so hardly anything else is left. So obviously breach of trust should come if cheating is there. So in this way, any other similar act, again we apply the similar kind of thing will be covered over here. So all this property offense, most of the property offense will fit over here, right? Okay, this is just a demarcation of it. But then there's something very interesting here, which happens when the law was advertised, but we are aware of this NEET controversy. They have come up with a special law on 20th June, that if there's any manipulation with, question paper and all, so it will be dealt with that. Over here also there's a selling of public examination question paper. Now this is one of the many provisions in BNS and other 3 laws where there will be an overlapping of the laws. An overlapping of the general law with the special law. So the question is what to do and how the court is going to decide, how the authority is going to apply, whether it's a case of a special law or general law. Right now the practice is to go for harmonious interpretation of a special law with general law. But this harmonious interpretation from the substantive point of view, it's not a big problem. But when we look from the matter of procedural point of view, then it becomes a very serious concern. Because the moment we apply, say, special law and something which is done under BNS, you'll find 2 different procedure applies. So if the case is under, say, Maharashtra Organized Crime Control Act, so there is a separate procedure given. If the case is under UAPA, there is a separate provision. But if the case is under BNS, then the provision of CRPC, which is BNSS, should be followed. So this particular overlapping, they have not clarified anywhere. So everybody is saying that at least there should be some clarification from the government that how to deal with overlapping of the laws. So this is one situation where there is an overlapping of the laws, that if someone is involved in selling a public examination question paper, whether that is organized crime or it will be underneath that particular special law. Moving on, for how long? 5-10 minutes? We go? Yeah. Okay, so I'll just complete this human body. In the next session, I'll take property and other thing. Among all the changes, definitely the most serious is this, 113, Terrorist Act. So as I said that it has been borrowed, most of the provision. So it is verbatim borrowed from UAPA. So what they have done basically, 5-6 provision of UAPA, just simply they have copy pasted without even changing the comma. So someone who is aware of, if you are dealing with UAPA case, so you can easily connect that is exactly same without even a single comma has been removed. Now, I'll not go in detail. All I wanted to highlight over here, from the layman's perspective and otherwise also, if someone is not involved in UAPA case or dealing in UAPA case, the general notion is when we think of terrorism, so something like 26/11 comes in the mind, a massacre, like what is happening in Bangladesh right now, those kind of things come in the imagination of layman. But the law is completely different. In fact, it is exactly opposite. So what is the law here? Intent to threaten are likely to threaten the unity, sovereignty of the country. That means injury, harm is not required. See, what I'm saying over here, there is a likely to threaten the security or economic security of the country. So I commit an act where there is some kind of threat or there is a likely to threat which will go against the unity of the country. So I may be branded as a terrorist. So what has happened during NRC time, especially this, the students protest in JNU, Jamia and all. So against all the students, they have applied UAPA apart from other provision. So what was the offense they have committed? So for example, in the morning I was reading about the order where the bail of JNU student was rejected, Umar Khalid. So the interesting part of that rejection order, where the Supreme Court said, in fact Delhi High Court and endorsed by Supreme Court, that Umar Khalid has given a terminology to the people to protest against the government regarding NRC. This is what they have written. That Umar Khalid has come up with terminology for protest against the government to overthrow the government. Therefore, we are applying UAPA and bail should be denied because bail will not be granted. So the difficult part and the most serious part is something which was a matter of special agency where sanction was required. Now it has become the general law of the land. So the only catch over here they have mentioned is, okay, I have not kept that. Automatically a normal police cannot file a case of terrorism. The option is given to SP. Superintendent of police will take a call that whether the matter should be taken up under BNS or matter should be taken under UAPA, because the definition is same. Now if the police decides that let's conduct an investigation under BNS, so that is valid. If the police decides that let's hand it over to NIA, National Investigation Agency, that is also valid. So essentially what will happen is, this is another thing which, being an academician, we have liberty to highlight all this. See, some of the changes, all changes are not legal changes. So there's some political touch over here, to be very, very honest. So what is going to happen, I tell you. If an act which fits under Terrorist Act under 113, and if the police of Bengal, SP, decides to take up the matter and investigate, chances are center will say that no, we'll hand it over to NIA because NIA is better placed to investigate that matter. But if same thing happens, maybe in say Uttar Pradesh or maybe in Madhya Pradesh, chances are the local police will investigate that matter. I hope you're connecting what I'm trying to say, right? So it's not just a legal thing, but there's something very, very serious. That means, okay, I'll show better. This are the 16 categories of people who can be branded as terrorists in the country today. It was already there under UAPA, but as I said, under UAPA there was a sanction was required from the government. A random police officer could not decide. Even SP could not decide under UAPA. This list is the most comprehensive, exhaustive list, I'll say, in the entire world. You will not find any other offense in anywhere in the world where there is a 17th category of people who can be charged for the offense. Because the generic term you find, advise, incite, advocate, these are generic terms. These are not legal terms. In the sense, commit, conspire, attempt, preparation are legal terms. But the moment this word comes in, where you advise someone to commit an act, where you advocate something, then it becomes very broad. So right now, if I advise someone that, see, there's something interesting going on, so we can think of or we can explore the option of joining say ISIS. Now I explore this, I just said this in public. Now somebody getting inspired from this, or somebody has taken this very seriously and has actually joined ISIS. So my function is definitely this particular thing which I have said in public will fit somewhere. That I have incite someone to join ISIS, therefore I am a terrorist. So the idea over here, maybe it appears that I'm talking about in a very simplistic manner, but believe me, when you read cases under UAPA, these are all targeted cases. And this kind of thing they have interpreted that there was an excitement from the person. This student has given this particular speech, therefore he should be charged in this larger conspiracy. So those things were confined for special agencies, sanction was required, proper evidence was required. At least one evidence was required before taking up the sanction. All this is gone. Now an SP can take a call and can file an FIR. Okay. So that is about human body, mainly the major changes. Now moving on to property, we can, I think, take a break or we continue. We take a break because this from here there's two more topics. Yeah, I think that will be better. We take some question maybe for 5 minutes on human body so that we can go along. If anybody having any doubt, any question. Yes.
Hi. I'm interested in knowing what the stated rationale for changing the laws was. And once you've read the laws, I'm interested in, of course, in knowing that if you think the rationale is different.
Rationale of changing the entire law? Okay, there's something interesting. So I was a part of, this Ministry of Law and Justice program, which is the formal program. I was one of the panelists where they are advertising the law, they're explaining law to the entire country. So they conducted one program in Kolkata also, just last month. So what they have said, just I'm saying from the official perspective. So the first thing they have highlighted in the first session, like I was in the second session, where the law minister came, that see, it was done, we have made it nyay, from punishment to justice. This is the message they have given, that there was punishment, now we have made it justice oriented. So the term itself, If we pick up the title, that is the most important reference we can get. But it's a misnomer. This particular argument should not be taken very seriously, because when you think of Indian Penal Code or whatever name you give, it's a penal provision. There's nothing justice over here. When we think of justice, it's an offense against the state. The concept of justice will not come over here. One person has killed another person. What justice is possible? By hanging the person, that will not be justice, right? So the government has advertised that there is a transformation from, punishment to justice, at least for this law, which, I beg to disagree. That is one they have said, which is not clearly the case. In fact, it is exactly other way around. If we look at something like terrorist act, if we look at organized crime, this is not justice. It is giving unlimited power to the police. So we call it police Raj. So if you listen to any expert who is speaking on the law, so everybody will agree on the point that extensive power is given to the state, extensive power is given to the police. So this is not in conformity with the advertisement they are making of the law. So it is exactly opposite of that. I'm talking about law as a whole. Now, if we go in detail, there are a lot of provision we can easily justify that. But at least for this, apparently what it seems, this is not about justice. And one may wonder that how come something like Indian Penal Code is justice oriented. It's a penal provision where somebody has committed wrong against the state and that person should get punishment or should not get punishment. But they have advertised in such a manner where the entire population of the country is seemed, oh, there's something related to justice. Not about justice. It can't be. It's not between two individual or group of individual where you promote justice. A person has committed wrong against the society. Either you penalize that person or you leave that person. Simple. So it's not fitting with the law. And the second thing they have said that they are doing away with the colonial legacy because it was a British made law, very old law. Definitely change was required. There's no doubt about it. But this kind of change, it has become double draconian law if we go for the analysis of the law. But that's a reality. Like I'm not writing from my interpretation or opinion. Yeah. Yes.
Is there a change in the defenses? The Indian Penal Code had the
Same.
It's
Exactly.
absolutely
No, absolutely same.
no addition.
No, here and there they have made. So they count it as change. Now this is all funny, like the things are going, especially when I was following this law minister's speech, law minister said, let's see, the entire country is saying that we have not done consultation. We have consulted, we have made these changes, we have worked, we have conducted this 1,000th meeting and all. So what is the change in general defenses? The general defense change is, there's one change in one provision of right of private defense, where it was after sunset was there, after sunset, at night. Basically it was at night. So we know at night means after sunset, before sunrise. They have removed night, they have written after sunset and before sunrise. This is one change. With this there are 170 changes. They have came up with a big document, so that is uploaded there in YouTube. So if you ITC, if you type, so they have opened the document that there are 170 changes. This is one of the changes. Yes, sir.
I just want to add to the question which Mr. Rudresh Mandal asked, that it is NAY, why it is NAY, and you are saying it is a penalty, but I think maybe it is a state. It is a case state versus the accused.
Right.
But the person who has suffered is an individual.
True.
So, if an individual has suffered, he will always want the accused to get punished. So it is a NAY for that individual. And according to me, I think
no, I take that. I take that from you. But can we all agree that the nyaya, that is punishment, and justice, whether one is synonyms of another? It can't be, right? See, I'm going in a very technical sense. You can think it is a justice because you are giving punishment to the person. My question is what you are doing for the victim. Now they have come up with some victim compensation scheme in few offenses. But when you think of justice, so there are a lot of theories, we will not go into that. The simple idea is that there should be an attempt to restore the position, restoration. Whether restoration is possible in criminal law, in a hardcore crime. In property offense, to some extent possible. Somebody has taken 1 lakh rupees, you pay back, some extent. But general hardcore crime, whether restoration is at all possible. Now to give a best example, so these are all in news. So for example, the case of Jilani, Iftikhar Jilani. So he was a journalist, he is still there, but not in India, journalist of Kashmir. So what happened in his case? So he was arrested, he was charged under UAPA for writing against the government. So obviously under UAPA the access to lawyer and all will not be given. So he was detained for 9 months. Then the first time he was produced in front of the court was exactly after 9 months. So his question is that why you have detained me? So the court said that since you are charged with for this offense, you have written against the government. So a simple argument that the thing which he has written is already there in the public domain since ages. So just type in Google and you see whether I am the first person in the world to write that. Then the court said that, see, this is a wrong application of law, the state should be careful and all. 9 months gone. Where is justice? Justice is not possible. See, in abstract sense, if you talk in this manner that somebody has taken 1 lakh rupees, you pay back with interest and all, to some extent fine. But Indian Penal Code, it's a penal law. It's not a justice-oriented law. So I'm trying to make this technical difference. For layman sense, obviously that argument I'll buy where you say that, okay, he has killed, so let's hang him. But those are super exception, right? There can't be justice. Think from the victim-oriented perspective. It's not justice-oriented law. Yes.
But that will be your own interpretation. Isn't
No.
it the justice delivery system that we are talking about? The Indian Penal Code is part of the justice delivery mechanism.
True,
Justice
true,
delivery
very
system
true.
of the country.
Very true.
So it's your perspective that if it is penal, it's not justice. Justice is not being done. Justice is not being delivered. The judges who sit there should not be addressed as the justices.
No,
So
obviously not.
it's just a suggestion from my side. If we can keep it focused on law and keep the the own individual perspective that that you are bringing in a bit out of the loop.
No, what I'm saying is, see, I'm not bringing my own perspective.
Suggestion.
No, that's fine. See, I'm not bringing my own suggestion. What I'm saying is that Indian Penal Code was there. So this term penal in a literal sense about punishment, right? So it's a part of the criminal justice system whole. There's no doubt about it. There's a a scheme of victim compensation is there in certain cases. This all are there. But the moment you change this penal to nyaya, that is justice, penal to justice, it will not become justice. No, that is exactly what's in the name. What's in the name? Okay, yeah. All right. Moving on to property now. This is one slide which is for me a very comprehensive slide to understand property, though we'll not go in detail of all this offense. See, I have marked in red, those are the changes, major changes. And as I said that most of the changes is about, penal provision, that is punishment. So they have made a lot of changes in something like mischief, basically about the enhancement of the punishment. Same for trespass and, cheating, extortion. So you'll find that 3 years has become 5 years, 5 years has become 7 years. So I'll not go in all those numbers. So basic change they have made, the major change is about the offense of theft. So what change they have done? First is the introduction of new category of theft, that is theft by snatching. It was already there. Now we have a dedicated provision. Now the interesting thing to look over here, the punishment remains same for normal theft as well as theft by snatching. So the first question comes that whether prosecution will ever go for something like theft by snatching, because this is a similar kind of situation like we have started early from mob lynching, that theft plus something is required. This something is that there should be suddenly, quickly, some kind of grabbing, taking away of the property. That means there's an additional requirement in theft and it becomes an aggravated form of theft. Now what we have to note over here, there is a slight difference in the punishment. Over here you note it may extend to 3 years and shall also be liable to fine. That means in case of normal theft, mere fine is a valid punishment, which is not there in case of snatching. Now the way of interpretation of this, one simple way to understand what is theft by snatching, which should be differentiated from something like extortion, robbery and normal theft. Whenever there is, the offender and victim are together, lot of cases will qualify for theft by snatching, because these are again very generic term they have written suddenly, quickly. Now for example, if I'm talking over a mobile phone, somebody comes and grabs and run away with my mobile phone, that's a classic case of theft by snatching, but there's no immediate fear. So the moment this immediate fear comes, this theft by snatching automatically becomes a case of robbery. For example, say somebody threatens me with a knife or some kind of fear has been generated, and then that person snatches my mobile phone or takes away my mobile phone. So that theft will become a case of robbery. So at time it's a touch and go situation between something like which is a normal theft. Now we have theft by snatching, and then it comes to the a serious offense of robbery and dacoity committed by 5 people, that become dacoity. So theft by snatching, this is a good law, I'll say. It was required. It has provided clarity in the law that something which apart from theft committed in a certain situation, that becomes theft by snatching. So this is one addition. The major change for me in property is the meaning of the term property itself. I'll say in theft. So what we had in IPC, there was a clear demarcation of corporeal and incorporeal property. So only corporeal property was the subject matter of theft. That means only tangible property. Now what they have done, they have written property of every description. So every description, of course, immovable property remains, they have excluded, that is land, thing attached to earth or fastened with the earth. So leaving immovable property, every kind of property becomes subject matter of theft. That means from now onwards, you'll find more cases of theft. The one which was not a subject matter of theft has become subject matter of theft. So it is very easy to add, all those cases of intellectual property over here, anything which is intangible, say something which is related to goodwill of the company. So all will fit under this new definition. So this is one of the broadest definition you will find in the new law, where they are saying every kind of property will fit. So the scope of the offense of theft has increased from 1st July by virtue of changing this particular definition. Further, for aggravated theft, they have added new things. Apart from tent, vessel and building, they have added, if something is done from article taken from the transport or theft of idol and all this, or government property, so they are making it aggravated form of theft, more punishment will be given. And again, a very important change here. So in stolen property, cheating was not there. Now this appears to be a very simple case, but for me this is a substantive change. Why this is a substantive change? So if we go to this particular demarcation, so see, leaving a case of cheating, now cheating has been added, theft, misappropriation, extortion, breach of trust, robbery, dacoity, that was the stolen property. Now we know that stolen property, dealing in stolen property itself is a substantive offense. That means, say I am having possession of stolen property, that itself is a crime. So it was there, but adding cheating, this is a very, very good move, because we are aware of from the experience and from the cases, the person who is the actual offender will never keep property in his own possession. So all this recovery which has happened in case of cheating is not from the main accused. So what has happened by now, by virtue of adding the term cheating in the stolen property, you will find multiple accused in case of economic offense. That means here, if we look at the previous definition of IPC, this word cheating was not there. The moment cheating fits in 317, that is about stolen property. So as a matter of routine, every case of cheating, you will find there are multiple accused involved, because generally the main accused will never keep the property in his own possession. So what we know from all the scam cases and cheating cases, that the property is recovered from driver, from family member and all. So those are taken care of over here. So a major transformation which will happen is, in case of cheating, you will find multiple accused from now on, which was not there. And it is a very, very good move. So keeping it in a very simple example, imagine a situation where, say, I have committed theft. So this thing is, say, a subject matter of theft, and I have given to you that you keep it. I have committed theft, and I'll take you after some time. Now you will be charged for stolen property. That was the law. But say before 1st July, if I would have said that I have cheated a person, I've cheated 1 lakh rupees, you keep this money, I'll take from you after some time. So you are not an offender. You were not an offender. Now you are an offender. That means if you know, if it is within your knowledge, or you have reason to believe, which is a dangerous thing. Reason to believe is on the basis of, a probability. It's like 51% type of cases. So if you have reason to believe that the thing which I have transferred to you, that is a subject matter of cheating, that is good enough to file at least a charge sheet against you for the offense of stolen property, if not for the actual cheating. So this is a major substantive change, though they have just added one word. So apart from this property offense, rest all remain as it is. They have not made any changes. So the only thing which new offense is about theft by snatching. Punishment they have increased almost in everything, starting from theft, obviously snatching, then misappropriation till trespass. They have generally enhanced the punishment almost in every provision. Rest all remain as it is, apart from these 3 changes. Now, okay, time for offense against women and children. Now this is one of the most discussed provision where people are talking about a lot of things. There are 2 extreme opinion over here. One extreme opinion is that this should not be a part of criminal law at all, because society has moved, and something like, relationship between 2 consenting adults should not be a part of criminal law. This is one extreme. The other extreme is that this law is a very, very a very loose law, in the sense this goes against the basic premise of consent. So these are the 2 completely opposite views. So I'll explain both. The first is about when we look at this particular offense from the literal sense, that there are 2 grounds. One is deceitful means, and second is false promise to marry. So false promise to marry is simple case. There are a lot of cases are there. So 1 or 2 references I have given. Deceitful means they have said false promise of employment, promotion, inducement. That means through suppression of identity and all. So if we just focus on deceitful means. So the question is that, say, if a person promises someone to give employment, promotion, or any kind of benefit, and if the person has taken consent by giving that particular benefit, that is perfectly fine. Because the key word over here is it should be false. That means if the promise is fulfilled, they can't be cause of action, right? So the ground reality is, we are aware of that people in the country, the household mate, they work for 100, 200 rupees. That is the ground reality. That means if the employer says that instead of 200, I'll give you 300 because you need money for medicine or whatever reason, but you have to give your chastity, honor, dignity, everything, then it is perfectly fine. So essentially what I'm talking about, I'm making 3 categories of cases here. One is a case which is about consenting adult. Those cases I'm not including here. So cases of living relationship, those are completely different. I'm also not including a case of sex worker. This is a 3rd category of case where the scope is given, perhaps for the first time, categorically with the letter of law, that you can purchase consent, you can purchase honor and dignity of a woman for any amount. Now, what is the problem with this? The problem over here is that there's a very big question that whether this consent is a free consent. Because right from the beginning, there's a power imbalance here. Power imbalance because those people who will use false promise to employment, promotion, these people, they enjoy a better position. So since the moment there's a power imbalance, automatically that nullify the consent. But now we have express provision over here that irrespective of power imbalance, if the consent has been obtained, if the promise is fulfilled, that promise may be for monetary benefit or otherwise, then this is perfectly fine. So there is a very serious concern about how the court is going to interpret this, because there will be a lot of cases about fake promise and genuine promise. So there is, the foresight is that chances of what has happened with 498A, similar kind of thing can happen now under 69. The other side of the story is also relevant, that after Joseph Stein and all, 497 is gone. That means adultery is no more a crime, but there is scope to add adultery over here also. That means, say a person is involved in consensual relation, which is not a crime, maybe a ground for civil action, but over here a person can come and file a case that, you know, there was a deceitful means used for the purpose of taking consent. So from 69, it seems that in the near future there will be a lot of cases about dispute regarding consent, that whether there was valid consent or there was no valid consent. So this is one disturbing provision for me, because the matter which will come in front of the police, that will be in a completely different manner. So there will be an admission of sexual intercourse, but the person will say that, you know, the consent was given under certain impression. That may be one. Second, the question will come that whether, you know, the consent which is given and the act which is performed, whether exactly it was same. So if we use one theoretical term, consent should be contemporaneous with the act. That means once the consent is given, it is not given for everything, right? Now, this particular idea of contemporaneous, contemporary, like should be the interpretation? In the offense of sexual intercourse, in the offense of rape, it's a matter of 1 second. 1 second before maybe no rape, after 1 second it becomes rape. So it can boil down to a matter of a second, not even a minute. So this idea of contemporaneous interpretation, that the consent was given, whether the act was done as per the consent, those are the cases which are going to come. So this is one provision which is a very loose provision where false cases may come in. This was already there, but now they have added a proper provision for employment of children for any kind of illegal act. So just they have come up with a dedicated provision. This offense was there, nothing new about it. Okay, one of the most discussed provision. So this law has been advertised for 3-4 things has been advertised of the law. One is about the zero FIR, that anybody can file FIR anywhere, EFIR and all, that is procedural side. And one of the major things they have advertised about the law, that they have done away with 124A, that is sedition. That sedition is no more the crime, which is true. 124A gone, it's no more crime. But when we look at 152, this name they have changed, endangering sovereignty, unity and integrity of the nation. So the question is whether sedition has gone or it has become sedition plus. This is not only normal sedition. Now, I don't have to go through all this provision. Just randomly, if I pick any word from here, say for example, in the 4th line, if I just pick this word subversive, that is good enough to say any standard dictionary in the world will say the first synonym should be sedition. So subversive is just one I'm picking. I'm not going into armed rebellion and all those things. So the moment, you know, this particular thing is definitely an aggravated form of sedition. Even if we go with literal meaning, maybe if the court comes up with an interpretation, there are cases on the point, cases like Kedarnath of 1962, Constitution Bench decision, where the court tried to balance the fundamental right of the person and the right of the government. But now the law which they have come up, they have even curtailed the power of the court to, you know, limit the or restrict this idea that something which is against the sovereignty or unity of the nation. So it seems that from the layman's perspective, we should be very, very careful when we are, you know, speaking, when we are writing in social media and all that, because now the law is more strict than what it was just 1 week back. So that is something which we have to think about. Okay, new introduction. So far regarding application of IPC, we know that IPC, there are 2 types of application, intra-territorial and extra-territorial. So intra-territorial, there can be 3 types of cases. The offense commences in the country, ends in the country. Offense commences outside the country, concludes in the country. Offense, commence in India and conclude outside, commence outside, concludes in India, and both in the country. Up to 3 categories we have. Now we had 4th category, only in case of abatement. That means, if we follow the illustration, the person has never come to the country. Say 2 persons in Pakistan, one person abates another person to commit crime in India. Now, this is good enough to apply IPC if this person can ever be prosecuted, can ever be detained in the country. So this is a new introduction, which is an extended application of IPC in case of abatement. So this was not there. Okay, community service I have already done. This is again a new provision, not very serious one, that somebody attempting to commit suicide to compel lawful exercise of power. So only community service is the major punishment, nothing serious. Okay, this is a slide which I am interested to discuss. A lot of things they have removed from IPC. So before coming to the main point, see, something which is covered by the special law they have removed. For example, false weight measure, this is covered by Legal Metrology Act, that they have removed. Housebreaking by night, I told you that this is, they considered a major change. They have removed that, they have added some other word. Transportation for life, they have removed. So transportation for life was basically life imprisonment. So this they have removed. Thug was outdated thing because it was targeting to a particular community. Now it is gone. The word thug is gone. Sedition is it's already there. 124A they have removed. They have changed the name. Adultery, it was already replaced. 497. Joseph Shah in case 2018. Attempt to commit suicide, again it was not a practical section, hardly any penalization was done. Counterfeit of coin out of India, it was removed, but because it was covered in some other provision. Now among all this, the first one is the most interesting. 377 gone. So 377 gone means the right has been recognized, the people from LGBT community, that their right has been recognized under constitution, so Natya Johar case. But the question remains, what will happen if it is a non-consensual act? So the question is that if it is a non-consensual act between a person of two same sex, then what will happen, whether there is any law in the country right now? Because 377 used to cover two types of cases, consensual and non-consensual both. What Supreme Court has done, Supreme Court has said that consensual act among LGBT, those are fundamental right, that should not be a part of criminal law. But what about non-consensual act? Because we know that there are a lot of cases of, gay, lesbian, and exploitation of, people in the name of all this offense. So that law we don't have right now. So if the victim is up to 18 years, we have a recourse under POCSO. But if the victim is above 18 years, we don't have any law. So the only hope right now is for unnatural offense, they have to apply minor offenses. If there's an injury, they'll apply assault. If it is between lesbian, like to a female, then some of the offense, they have made it gender neutral. For example, offense like disrobing has become gender neutral. Voyeurism has become gender neutral. So those are small, petty scope for removal of this unnatural offense. So I don't find any reasoning for removing 377 in toto, because the non-consensual act should remain crime. If it is consensual, then it's a right of fundamental right and all. So this is one major gap. There are other gaps, but this for me is the most major gap which they have done in BNS by removing 377 completely. What court said, so what they have done over here, when you look at the scheme of the act, they have followed guideline of the court in certain places and they have not followed in certain places. So in Natya Johar, there's a very detailed discussion on this, but in Natya Johar, nowhere they have mentioned that even non-consensual act should go. So they are not saying that entire 377 should go. So either it's hurriedly they have done it, or whatever the rationale, nobody knows that why they have removed this entire thing. So this is about, I think we can take question now, because see the discussion can go on and on, so but it's better that we take some questions. So these are the major changes which I have highlighted. These are all the major changes. There are a lot of other changes that I said, but those are minor changes, like in punishment and all that. So I'll stop it here. We'll take question or your comment, discussion, whatever. So that will be, yes.
Good evening, Professor. Thank you for a wonderful session. So can you bring out once more the difference between defamation, say a journalist defames the state, and sedition? If there is such a definition, if there is such a difference in the definition of sedition, is defamation of the state sedition? Is my question to you.
That's a very good question, actually. This thing has been discussed. The precise case on the point is Kedarnath versus State of Bihar. 1962 Supreme Court decision, that's a constitutional bench decision. This case, I'll come to the case that what they have mentioned, but this case has come under scanner at least 100 times in High Courts and Supreme Court. Somehow this particular precedent survives even today.
So if we have to go from precedent point of view, it is the Kedarnath case because we need 7 bench to overcome that. Now, what they have done in Kedarnath case, they have gone through, all the decision of Privy Council. They have borrowed idea from other jurisdiction and clearly they separated this point. So if I keep in a very layman's sense, what Kedarnath said that government and Narendra Modi are 2 different entities. If I have to use in the contemporary sense. Government is one entity, Narendra Modi is another entity. So if you are saying something against the government, so just speaking against the government, automatically it will not become crime because those are covered by Article 19. Those will not come under exception of Article 19. That is my freedom of speech and expression. Okay. But if I say something directly against Narendra Modi or the person who is ever like minister and all, then this idea of defamation may come because that's a personal attack. That is one thing. Second, they have clarified that even if I am saying something against the government, say that is my perspective that this government is good for nothing and this government should go and all, perfectly justified. What is the additional requirement is, apart from the criticism, apart from even defamatory statement, I have to do something which is an attempt to overthrow the government. Subversive, overthrow the government. That means, but unfortunately what they are, this theoretically I have said, which was done in Kedarnath. But unfortunately, when you read all these cases, this particular principle they have not applied. In fact, it's a hand-picked thing, it's a cherry-picked thing. It's not uniform application of 124A. Like I'll not go in detail of cases and all, but when you just randomly, if you go through say 20 cases on 124A over a period of time, you will find that it is not uniform application of 124A. They are applying according to their requirement. Now again, if I give reference of Delhi, so Delhi, they have come up with an idea that there is something called larger conspiracy regarding Delhi riot. Now the question is, what exactly is this larger conspiracy? Criminal conspiracy is fine. But since this person was not directly involved in Delhi riot, all the students, so they are saying that students are involved in larger conspiracy and they should be charged for the riot. So theoretically things are settled, but practically it's not that way. Yeah.
One follow-up question. What exactly is the difference between 124A and 152?
There are quite a few. See, for me this is very, very broad. I tell you why. If you look at this particular, all this thing, the first thing to note over here, it is inclusive provision. Again, this is not exhaustive. Visible first. Second thing, this is broader because the medium has electronic and all was not there. Okay. So means-wise, they have broadened the scope. Second thing, by use of financial means or otherwise. No, these are dangerous legislation. Very, very dangerous legislation. It was not there. Funding somebody financial, what is this otherwise? So basically they have given scope for everything under the sun.
But that has to be read in context.
In context. But how you read, what else you will have? So something it will fit, right? It's
A financial donation which excites subversive activities or feelings of separatist activities.
Yes.
So that would be sedition.
Sedition. The whole
a donor to a, let's say, an illegal party would also be
good enough. Good enough. This was not there. So 124, I don't have, if we have Bare Act, we can check. It was very flat. Word spoken, written against sovereignty, unity of, it was very broad, but not this way they have not done it.
Somebody writing against or printing something.
Printing something. So the reason I'm saying that when we are writing in social media, when we are interacting in public, we should be very careful when the government is involved. Because they have broadened this. When we are, as you said, we are funding a particular program. That is good enough to say that.
I have donated 100 rupees.
I have donated 100 rupees. That's it.
My name is found in the list.
Yes. And the problem with this law right from the beginning, for the past 2 hours, I'm trying to say one particular thing that, see, the provision is not exhaustive. So it can go either way. It becomes a subject matter of controversy. Now, assuming the best possible scenario for the accused is that the court will say that this particular interpretation is not correct. But this is going to happen after 10 years.
Thank you, Professor.
Yeah.
Good evening, sir. With section 377 removed, what legal recourse can a man who has been a victim of rape or sexual harassment take?
That is a major gap they have created. But for the time being, see, it depends on the nature of the case. So this particular question, a lot of people are asking me. So I have given this suggestion to police officers and other people that you cannot say that there is no recourse in the law, because that is the worst thing you can say as a law enforcement agency. Now, depending on the nature of the case, I have suggested what in other places that, see, if there's a detention, then obviously you start a case of confinement, because this thing will not happen in open public, right? There'll be some within the four wall it will happen. So there can be a case of detention. If there's an injury, it can go on till grievous injury. If those provisions which are gender neutral provision, those you can apply, where the victim can be male, female, either of that. So depending on the nature of the case, we can apply, though it will not do justice to the the offense. It will not cover the actual wrong, because the gap has been created. But for the time being, like, there's no other option, just to apply all this minor offense, and maybe they'll add 4 or 5 together. So starting from confinement, kidnapping, assault. So otherwise there's no option. Yes.
Just to follow up to the previous question, what Devanjan Babu was asking. So was it also not that if you were printing something against the state earlier, you could still be charged under sedition? I'm giving you just an example. A senior journalist of ours, he was once told by a Maoist leader to deliver a seam when he was going on an assignment to Chalda. So he said, no, I can't do this. This would amount to sedition. The police can arrest me. So this risk of what is sedition and what is not, if I'm printing something, because there have been multiple instances where journalists have been arrested for sedition,
right,
but just for writing something. So
right,
was it not that it was also earlier?
It was there, but as I said, that, see,
that's what I'm asking.
No, see, one is about medium. I agree with you. The medium was same, but they have clarified electronic and all. But when you look at the ground, so the ground they have broadened. If you check 124A, all this ground, financial, all this was not there. So the simple case which you are talking about printing, obviously it was sedition, it will remain sedition. There's no doubt about it. But they have added more ground over here. So if I'm sponsoring this particular, that somebody wants to print something, I have given money as pointed out. Don't you think that is good enough that I'll also be charged under 152? That I'm sponsoring something which can or could be sedition. But the major thing, the major takeaway from this, what I'm saying is that, see, there's a clear demarcation between what is the law in place and the application of the law. So precisely the case which I have mentioned, Kedarnath case, if you follow, so they have clarified this difference. That merely writing against the government, merely printing something, that is not per se wrong. That is covered under Article 19, that is the fundamental right of the person. Unless there's an attempt to overthrow the government. Now, attempt to overthrow the government is not simple thing which is writing against, say, a particular government. So what they have done over here, see, theoretically things are not that bad if you look at the interpretation of the code. But the way they have applied, that is a matter of serious concern. And by the time this call will be taken, whether there was an attempt to overthrow the government, 10 years is gone. So now they have given more scope. So this something like financial otherwise. So all this otherwise and all they can interpret in any manner. So at least on this point, there's a consensus among all the legal experts today that this is more than a sedition. There's not a single dissent you will find in the country where anybody is saying that this is less than sedition or exactly sedition. Because 124A was not this much detail. It was not this elaborate. Yeah. Yes.
So my question goes back to the first hour. You made the technical difference between punishment and justice. And you said, of course, in my view, that that the concept of justice is not consistent with criminal law. It's more punishment oriented. So then my question is that, let's say, of course, if someone is murdered, then can the victim never get justice but only punishment? And is that the idea? Of course, and therefore, of course, is there a concept of justice that is compatible with criminal law?
See, theoretically, yes, I'll agree with what you said, theoretically, yes. But I'm talking from a very practical sense. See, the question which you asked about the, the intent behind this change, and like the intent and what the change has happened. So I said that, see, there's a contradiction here. The intent was that there's a shift from punishment to justice. But by just changing name And it's just like changing the heading, the banner. Entire thing is same, almost same. And the changes which they have done, this 5%, 7% change, those are not justice oriented. Even for the sake of argument, I take this as justice, this criminal justice. But these are not justice oriented. These are more draconian law. 152 is more draconian than 124A. Terrorism is more draconian than what it was in IPC. So I at least personally, I don't find justice here. But certain things they have done good. Like, it's not one-sided. There is a big social message when they have kept something like mob lynching. There's a big social message when they have covered, the punishment. They have differentiated between offenses which are against women and children. Those are wonderful things. So entire thing is not bad. The entire law is not bad.
My question wasn't limited to this code, but of course, like criminal law in general.
Okay, criminal law in general. In the next session, we'll be covering that. So this particular interaction is actually incomplete. Because when we think of criminal law, see, just speaking about this is wrong, this is crime, that is not sufficient to appreciate what criminal law is. When we connect procedural law, so this is a dead letter basically. The life is given through procedure. The moment we put the procedure in the law, then it becomes a proper criminal law, right? When we think from the practical point of view, that what is the power given to the police? For example, when you think of any particular provision, now the power to the police is, police can detain a person only for 15 days. It was there 15 days. But the first 15 days, it used to get over. Now that power has been extended till 40 to 60 days. Now this appears to be a very simple thing that, okay, 15 days detention, it remains same. It's not same. Whenever the person will come to apply for bail, the police will say that we need this person for a custody. Now they have changed one term. So what essentially they have done, they have deprived the liberty of a person. There is a scope they have given that entire period of 60 days, a person liberty can be deprived just like that. So the moment we put procedure in all this, then it becomes real criminal law. Right now it's just about, demarcation, this is wrong, this is not wrong. It's more of abstract sense. So criminal law is the real life comes the moment when it comes to procedure. Procedure is the practical side of criminal law. And this is the theoretical side of criminal law. So in the criminal justice system, you will find 95% is procedure. It's not all this, crime. But we start from crime because we need some kind of base, a background to understand what happens in real life. So when we are covering procedure, we are covering what happens, how this law interact with the society, how this law is in play in the society. So I think that time we will be in better position to appreciate.
Since we also have some people joining online, and if they have any questions. Shurjoda said we can unmute. So, okay. Since we don't have any further questions, I'll invite Mr. Arindam Sarkar, partner, to extend the vote of thanks.
Good afternoon, everyone. It's been an absolute honor to be a part of this workshop, and I would like to extend my deepest gratitude to Faisal on behalf of Fox and Mandal. Can we have a huge round of applause for him? Next, I would like to thank the people who are behind organizing this amazing workshop. To begin with, the Bhawanipur Education Society. Thank you, sir. NUJS, any representative from here? Okay, the alumni. And of course, our very own Fox and Mandal team, Shurjo, Colonel Mukherjee, and his team, Mahima, Dishari, all of you, Shovik, thank you so much. And last but not the least, everybody out here who've taken out time from their busy schedules on a Saturday. Thank you so much for participating. Let's all meet again next Saturday at 11, same place. Thank you so much.